Hi, everyone. This is Ruby Powers with Powers Law Group. Today, we're going to talk about motions to reopen an immigration court. So I'm a board certified immigration attorney with a full service immigration law firm, Powers Law Group, located in Houston, Texas. We also have a location in the Woodlands, not too far from our Houston location. I'm board certified, but I'm also a professor and presenter on law practice management and small business at South Texas, College of Law, HCC, and around the world, and also an author about law practice management, small business. I'm an advocate for immigrants' rights and in the community at large. So today we're going to be talking about immigration court, specifically motions to reopen. So just a little bit elements of immigration court. I mean, we're gonna make this brief, but we want to give you like an idea of some things, because maybe you have a deportation order, you have an in absentia order, which is a fancy word to say you weren't there when the hearing, when you were ordered deported. In absentia, you were absent. Or you had a deportation order in the past, and some changes arose. So just a couple of terms and ideas. The notice to appear is what summons you to go to immigration court. And there's been some case law, the cases that have come out about having properly filed notices to appear, including that have date and time. So that's another conversation, but it is something that's relevant to this conversation. So the notice to appear usually brings you to court if you had a crime or something that gets you found and put into the system, or potentially you have a referral because the case was denied and it gets sent you to immigration court. Now, there's various types of forms of relief. Some things are just available in court, some are available inside and out of court. But so that's depending on what you're eligible for. This impacts your case. There's initial and final hearings. We usually call it master calendar hearing for the first one. They could have multiple masters. Usually, though, judges don't want to have that many of them. There could also be in the final hearing, or we call a hearing on the merits, and HOM hearing on the merits. Now, there can be some other preliminary hearings, but these are the two predominant ones that they're called. And then there's the consequences of failing to appear are pretty big. You could get the in absentia order or a deportation order, and then that either necessitates appeals or a motion to reopen. Now, not always are you eligible for filing a motion to reopen. So this is what a notice to appear looks like. They can look a little bit different, but this is one that was redacted, it looks like. But this is summoning somebody to go to immigration court in Chicago, and there's usually the name, the A number, more information, but it generally says a few allegations and a charge, and that you're ordered to appear. In this case, this NTA, notice to appear, doesn't have a date and time, so that would be deemed deficient. But anyway, this is one that was, so this is from 2012, but anyway, this is just one to look what it looks like. Now, consequences of failing to appear. So if you don't go, then that would be a removal in absentia, and that has a lot of different consequences for future forms of relief. And it's a lot harder to reopen the court case, so you need to act quickly. I'll just go back for a second. If you have an in absentia order and you later file an I-130 and you're trying to move forward, and you maybe even you reopen the court case and you're able to get the case dismissed, it could be a possibility that they make a finding of in absentia at the consular appointment and then ban you for 5 years that there isn't a waiver for. But the other thing is, if you did submit an I-212 waiver for an in absentia, they could potentially say that it's an in absentia order, a deportation order, and so that you have the 5-year bar. So you really want to be careful about in absentia findings. So post-immigration court, let's say you go to court and you don't get the approval that you were looking for. What do? You must file a BIA appeal within 30 days of that immigration judge's decision. You could do a motion to reopen 90 days after the decision, but there are exceptions, and we're going to go over that. And there's also a motion to reconsider within 30 days. But the timelines are super critical. So the motion to reopen in changed circumstances can mean a client has an alternative basis for avoiding removal. That it must show material new facts or evidence unavailable during the original proceeding, and that could not have been discovered or presented at the original hearing. So some of the common grounds to reopen include changes after the final order, removal or exclusion. So that could include changed country conditions, could be change in elections, or some significant matter that happened, domestic violence, in absentia order, ineffective assistance of counsel, change family circumstances, change in law. And change of law there's lots of ways changes. So this could be something that's really applicable to you. Now, I want to mention something about prosecutorial discretion, because we've seen an uptick in the last couple of years of a lot more exercise of prosecutorial discretion. And in fact, in a Supreme Court case in June 2023, it further clarified that the Biden administration has the right to exercise personal prosecutorial discretion. And so as of July 28, 2023, OPA attorneys will again apply the CIEP as outlined in the September 2021 memo and discussed in the Doyle memo when reviewing PD. So they're going to be able to evaluate independently whether they exercise the prosecutorial discretion and unilaterally moving to dismiss or administratively close cases, agreeing to stipulations on issues of relief, bond, continuances, and waiving appeal, or joining in motions to reopen proceedings. So what does that mean? Well, there's a lot more leeway and use of prosecutorial discretion for the prioritization of the cases that the government really wants to be in immigration court, and the ones they don't want to use their resources for, they're more willing to, like it says here, stipulate or agree to dismiss, or agree to reopen. In fact, we've been exercising a lot of prosecutorial discretion in the last couple of years, and it's been great. And this also could apply to you if you have a deportation order and you need to reach out to apply to get prosecutorial discretion to help with reopening or addressing the matter of an absentia order or something of the like. So just make sure to keep that in your back pocket and use it. So procedural requirements when we're talking about motions to reopen are the number limits of how many you could have, the timing, the filing jurisdiction, and documents in general. And again, this is not legal advice. I'm giving you some general concepts, overview, and this does not take the place of having a consultation with an experienced immigration attorney. So straight up from the UIR websites, it says there's a number limits for motions to reopen. So parties permitted only one motion to reopen. Really, only one? Yeah. So, but there's some exceptions to the limits of motions to reopen. They may be filed outside the time and number, only in specific limits, only in specific circumstances. And those are the ones delineated here. So changed circumstances, in absentia proceedings, joint motions, DHS motions, pre 1996 motions, battered spouse, children, and parents, and this other considerations. So we did mention the changed circumstances earlier on, and we've made a big deal about in absentia proceedings, so those are important. But joint motions are another great option, especially in light of prosecutorial discretion, and that means that the both parties agree to reopen the matter. And so these are ways that you can overcome the number limitation. So maybe you filed a motion to reopen before, but now you're trying to do it again, and this can give you an option for being able to proceed and not be limited to just that one time. Now, generally what you need to do is a file within 90 days, but There's also the options when it was changed country conditions, in absentia orders, joint motions, and requesting a sua sponte reopening. So there's times when you can ask to reopen when it's not within those 90 days. I mean, I've been doing, we've been doing a lot of these right now, but we've been reopening a lot of cases that are old that usually the individual didn't know about, or they were young, or something happened. And it's great because we're allowing that individual to be able to move on with their life and find another form of relief. And in some cases, we're doing joint motions. We're reaching out with prosecutorial discretion generally first. We don't get a response back, then we're filing it directly with the court. But sometimes we're able to get that joint motion filing. And there's usually a sua sponte request with the motions to reopen as well. So these are some things to consider. The filing jurisdiction, it has to be filed. So like, let's say you live in Houston, but the case that you had the deportation order was in Boston. Well, you need to file it in Boston, even though you live in Houston. And what we normally do is file that and then also have a change of venue prepared to move the case to the new location, new court jurisdiction. Now, you want to make sure that you have evidence to support your claim, whether it's the changed circumstances, the sua sponte, the new form of relief, whatever it may be, the communication of why you didn't know about the in absentia order. So there's a lot, or you didn't know about the hearing notice to appear. So these are some of the things to consider. And then one other thing that's important is automatic stay. What does that mean? Well, just to let you know that when you do a motion to reopen, in some circumstances, that's an automatic stay, which means you can't be deported while it's pending. But that's not for many circumstances. Its motion is filed, does not automatically stay in order of deportation or removal. But a motion to reopen requesting an in absentia order may be rescinded. Ask the immigration judge to reconsider why they didn't appear, and that is one that you can do an automatic stay. So when it's in an absentia order. Okay, so I try to do this in under 15 minutes, and it's complicated, but we're really just trying to get you some information and some things to consider. So if you have a deportation order in the past, you had an in absentia order, consider some of the stuff we talked about. Definitely have a consultation with an experienced immigration attorney. We're going to do this in Spanish as well, but these are things to consider. And I mean, you do not want to mess around. You want it to be a good motion to reopen. You want to consider all your assets, your prospects. You want to reach out to OPLA if you can do to get a joint motion, and you want to use this to the best of your ability. So feel free to reach out to us if you have any questions. Next week, we're going to be talking about conditional residency and what is the I-751. So our number is 713-589-2085. We have several, a handful of attorneys. We have Cynthia Millian, who speaks Spanish. I speak Spanish and some teeny bit of French. It's somewhere in my head, and a teeny bit of Turkish. And Larissa speaks Ukrainian, Russian, and English. And so you can reach us at this number on social media, watch our other material. We're located in the Heights, but we're also in the Woodlands. So thanks for watching. Feel free to share this with a friend or somebody else that can benefit from sharing and reading, watching this. Thanks. Have a great day.